The General Data Protection Regulation, or the GDPR, came into force in the UK and across the EU member states on the 25th of May 2018. The months and indeed years before that saw a monumental effort from organisations working to get ready for its implementation, no more so than within the retail finance sector. However, even with all that effort, few would be willing to say that the job's done. In practice, the pre-May period was really, for the most part, the first stage in a much longer journey to compliance with this far-reaching regulation. So with many clients seeking to benchmark and understand what is on the horizon, I thought it would be useful to share some observations on the focus of that activity post-May. So the days and weeks around the 25th of May saw a veritable snowstorm of privacy notices being issued, and in some cases reconsenting. This was the most visible demonstration of a huge repapering exercise internally and externally to create not just new notices but document a plethora of policies and standards. We are now seeing that accountability exercise deepen, with more detailed controls being documented and, more significantly, operationalisation, the new buzzword, but this is really occurring in earnest, embedding the procedural and technical requirements of the legislation. And we're going to see that, I think, continuing as a key feature for the diary for 2019. In practice, some of the repercussions we're seeing, well, the volumes of DSARs and other rights requests seem to have increased for some clients, not necessarily for all, but actually overall we are seeing an uptick, and processes and scalability are really being tested. So we are seeing a number of clients work to further improve their escalation and scalability, their resilience to deal with scale increases. And looking at alternatives both technically in terms of system changes, process changes, but also possibly other solutions being explored to give them the speed and scale required. Similarly, we're seeing approaches to DPIAAS being tested, with some real challenges being encountered practically in getting operational completion, in particular in relation to robust content and analysis. So clients are working on further training around this, and actually also simplification in terms of some of the processes and the templates that were created pre-May, making it easier for the business to complete them and work as part of a team. We also saw some helpful input from the European Data Protection Board on the list of activities that were put forward by each of the data protection authorities as activities that needed a DPIA to be triggered. The ICAO was one of those, and so that's been helpful because actually it's gone back to the opinion they previously issued, and actually it's taken out some of the triggers which the ICAO had previously indicated did need a DPIA. So helpful, I think, in relation to that. What else are we seeing? Well, related to DPIAAS, we're seeing this concept of privacy by design come to the fore. Not necessarily something that was talked about hugely pre-May, but we are seeing it now, very much a focus of scrutiny, in particular in relation to how you deal with that implementation in practice. Increasingly, of course, we're seeing fintech solutions being procured, which is a consideration there. So we're seeing that not just DPIAAS being completed, but also in the context of new procurements, these additional requirements being embedded in relation to the contracts with third parties from whom these are being obtained, and also the developments of policies and standards internally with the business to enable that to happen. In relation to contracts with vendors, I'll briefly just say the battle to get those contracts in place to the new standards under Article 28 is an ongoing one. It was a huge paperwork exercise. It does continue, and I would not say at this point there is a kind of norm established around the tricky issues around liability, though we are, I would say, seeing more often than not liability capped and perhaps some increased use of what we might refer to as super caps to deal with potential liability. We're also seeing people get more used to the concepts of vendors and third parties they deal with being controllers, not necessarily being processors. Not going to be so surprising to you that record retention is one of the big pieces both now and indeed for 2019 programs for a lot of clients, such as the big operational challenge of actually embedding the rules here and making sure data isn't kept longer than is actually necessary. Training continues to be a focus. This was one of the things that was often left to the end of programs, so we are seeing that now kick in. And so for clients, they are looking at how they go about embedding those training programs. Have they done enough? How much are they going to repeat training? And actually, how are they actually making sure that people are taking that training and making sure they can evidence it has been undertaken? So as you can see, there's a lot going on and there's still much more to do. But it's not all about GDPR. So watch the next podcast and I'll be talking there about some of the other issues we're seeing on the horizon.